This morning, I just want to talk a little bit about what the legislation is governing the use of personal health information in New Brunswick, what the REB guidelines are governing the use of PHI in research. I want to talk a bit about consent for research and waivers of consent in research, how to safeguard your personal health information, what de-identification looks like, and just want to give you some practical examples of privacy issues that we've experienced over the last couple of years in research services. So I just want to make a disclosure. I'm not a privacy expert. I do have certification in privacy, and I do work closely with our Chief Privacy Officer, but I'm primarily responsible for privacy with respect to research. And I have reviewed hundreds, maybe actually probably more research studies over my last 20 some odd years working in research. So I've seen just about everything. I just want to start with a couple of definitions, and I'm sure you're all very familiar with these, but privacy is actually about an individual's right to govern who has access to their information. So it's about people and their sense of being in control of their information and what they want to and what information they want to give to whom and when. And confidentiality is really about a custodian's right to treat identifiable and private information in a responsible way, and it establishes that trust relationship and that there is an expectation that the information that is collected will not be used only in ways that it was consented to be used. So if you look at the New Brunswick privacy legislation, what do they define as personal health information? This is a really busy slide, so I'm not going to read it all. I just want to give you an idea of what's included in the legislation. So it really relates to an individual's physical or mental health, family history, healthcare history. It's their registration number, relates to the provision of care provided to them. It relates to information about payments or eligibility for healthcare. It relates to donation of an individual's body parts or substances, and it identifies the individual substitute decision maker. It also identifies an individual's healthcare provider. And just with respect to the last one, I want to point out that I have seen a lot of research study applications come in where they say the information is going to be de-identified. However, one of the variables that's to be collected is actually an individual's healthcare provider's name, and that actually is identifiable information. So that's one that's not always well known in the research community. So the privacy legislation governs the collection of personal health information. It governs its use, disclosure, retention, and destruction, and it's actually centered on healthcare. So that is the focus of the privacy legislation, is around the provision of healthcare. And what it tries to do is balance the two objectives, which is a patient's right to privacy and also a custodian's need to collect, use, disclose, and retain personal health information with respect to managing somebody's healthcare. So where does the research fit into the privacy legislation? Well, there's actually an entire section, section 43 is dedicated to research, but what I wanted to point out here is that within the legislation, there are definitions at the beginning of the legislation, and one of the definitions of a custodian includes that researchers conducting a research project approved in accordance with the Act actually becomes a custodian of personal health information. So under the legislation, you as a researcher collecting, using, disclosing personal health information actually become a custodian of that information. So you're subject to the legislation under that section. So what's section 43 look like? So section 43, with respect to research actually says that a custodian may disclose personal health information to somebody conducting research only if the project has been approved under this section. And under this section, it states that approval may be given by an REB, and as long as the REB meets the requirements prescribed by the legislation. But it's interesting to point out that nowhere in the legislation does it define what an REB is or what an REB's requirements are. It also states an approval for a research project may be given by an REB as long as the following provisions are addressed, so that the research is of sufficient importance to outweigh the intrusion into privacy. that the research cannot be accomplished unless personal health information is provided in a form that identifies or may identify individuals. So may identify is key there, because there are a lot, which I'll talk about later, there are a lot of different variables that are collected that may appear to be de-identified, but actually, if they are used in connection with other information, may become identifiable. That the individual to whom the information relates has consented to its use and disclosure, or it's unreasonable or impractical for the person proposing the research to get informed consent. And also, it states that the research contains reasonable safeguards to protect the privacy and security of the PHI, and that procedures to destroy the information or to de-identify it at the earliest opportunity are stated. So an approval under this section is conditional upon the person proposing the research and entering into an agreement with the custodian in accordance with the regulations. Within this agreement, there has to be stipulations that there will not be publication of personal health information that could reasonably be expected to identify an individual, that the use of the personal health information requested is solely for the purpose of the approved research project, and that it has a stipulation that there will be safeguards in place to protect the information. So essentially, Section 43 says a research project must be approved to release personal health information by an REB, and it must have an agreement in place with the custodian. So this is why we're asking sometimes when I review research projects, if the information is being disclosed outside of the institution, that you have to have a data sharing agreement in place, because it's actually required for every research project by law. So what are some of the ethical principles or the underpinnings guiding privacy and confidentiality in research? So two of the most important fundamental principles are respect for persons. And what that means is individuals should be treated as autonomous agents, and they should be allowed to fully exercise their rights, including the right to their privacy and the right to have their private information remain confidential. And it also concerns the principle of concern for welfare, which means to do no harm and to minimize the risk and maximize potential benefits. And what that means with respect to privacy, or what it looks like, is that researchers maintain the privacy and confidentiality and help to protect participants from potential harms. And some of the potential harms for release of information from a research project include psychological harms, embarrassment, distress, could be social harm such as loss of employment or damage to one's financial standing, or criminal or civil liability. So what are the REB guidelines with respect to privacy? The privacy legislation, and within the privacy world, they do refer back to the TCPS2, specifically Chapter 5 on privacy and confidentiality. So within this chapter, it states that researchers will safeguard the information entrusted to them and not to misuse or wrongfully disclose it. It also states that institutions shall support their researchers in maintaining promises of confidentiality. So this would be seen through things like sessions like this, research education and training, proper support systems, mechanisms, platforms that are secure to store personal health information, those types of things. So some of the administrative, education and training agreements, and technological support, secure systems to store personal health information that's related to research. That researchers will describe measures for meeting confidentiality obligations and explain any reasonable foreseeable disclosures. So when we talk about purpose within the legislation, it has to be very clear that the purpose for collecting the information is expressly known to the research participants, and the information is only collected for that purpose. When there's a change in a purpose, that may require reconsent to research participants. It may also require an amendment or a change to a data sharing agreement. Researchers are required to provide details to the REB regarding their proposed measures for safeguarding the information for the full life cycle of the study. So we need to know how you're going to collect it, how you're going to use it, what your dissemination plan is, your retention plan, and how you plan to dispose of the information when it's no longer useful. So these elements, anyone who's completed a research study application knows that Section 9 in the research study application really walks you through these things and asks you to describe what it is you're collecting, how you're going to use it, how you're going to share it and store it, and then dispose of it at the end of the research study. And then also institutions or organizations where research data are held have a responsibility to establish institutional and security safeguards. So it's not only responsibility on behalf of the researcher, the institution where the research is happening also has an obligation to ensure that there are security safeguards in place as well. So more in the TCPS2. So this section is with respect to researchers who have not obtained consent for participants for secondary use of identifiable information. So this is talking about waiver of consent. So a lot of times researchers will propose to use information that was collected, let's say for clinical care purposes. So if they want to go back and look at that information through a research lens or from a research perspective, and they propose that to do this without individual informed consent, that they can do that. They can request a waiver from the REB. As long as they meet these criteria. And so all of these criteria actually have to be met in order for the REB to consider a waiver. So the identifiable information needs to be essential to the researcher, to the research and the researcher. The use of identifiable information without their consent is unlikely to adversely affect their welfare. They take appropriate measures to protect privacy of individuals and to safeguard the identifiable information. So just with respect to this, there is kind of a standard out there that says that any cell that has 5 participants or less really should be suppressed within a data set, because if you have 5 or less individuals in that data set, the likelihood that they would be identified is very, very high. So there's that general rule to try to censure out 5 cells of 5 or less. That researchers will comply with any known preferences previously expressed by individuals. Some people have advanced directives that they don't want to have their information included in any type of research project. So those kinds of expressions have to be respected. That's impossible or impracticable to seek informed consent, and we'll talk about this a little bit more. This is really a difficult and a challenging one to meet or to define, especially if you think about COVID over the last couple of years. When we first started with COVID, we really didn't have a whole lot of number of cases. So there were requests for waivers coming in, but the REB didn't find that it was practical or it wasn't impossible to get informed consent considering the low numbers. And also that researchers have obtained any other necessary permission for secondary use of information for research purposes. This would be in the form of your data sharing agreement or a letter of support from analytics or something like that to say that they agree to release the information. That's specifically with respect to us, the kind of information that we're looking for. So if you've met all those criteria and the REB feels that you satisfactorily addressed all of them, more than likely they will approve your waiver of consent for secondary use of data. So consent in research, our default position is express written informed consent. But as I mentioned, there are exceptions for secondary use of data. When you're obtaining informed consent, describe the purpose, the methods of collection, who will have access to it, length of retention, intended disclosures, a method of destruction. And those of you that have put together informed consent documents know that all of these elements, with the exception of destructions, are included in the informed consent document. But we always say what we need your information for, how we're going to get it, who's going to have access to it. In the confidentiality section, you'll see the quality assurance manager, which is Stella's role, the REB, any regulatory authority. So if it's subject to Health Canada or FDA, these people need to be listed. The sponsor needs to be listed. And that's so that it covers anyone listed so that they would have access to their information. So if the consent for study participation details all these things, details the access, use, and disclosure of PHI, and the study consent is obtained prior to access to this information, then you can consider yourself in compliance with the provincial privacy legislation. So some specific cases, consent to access for PHI for recruitment purposes. So we always ask, how will you identify your research participants? So it has to be somebody who's involved in the participant or potential participant or the patient's care. So if it's somebody within the circle of care and you have a research project, they could obtain the patient consent to have their health record reviewed by a research team for eligibility screening. And this can be case by case, or you can get a list of patients once they've agreed to have their chart screened. You can get a list of them and then proceed with screening, but only after they've consented to have their information reviewed. Verbal consent for this is acceptable, but it has to be documented somewhere. So somebody has to make a notation next to the patient's name that they have agreed to have their information accessed for screening purposes. Documented consent using a consent template for access to PHI. Some of our research teams actually have templates for this. And so they have a form that it says, you know, we give your signature below indicates that you've given the research team permission to review your chart for research purposes. So these can be implemented at a team or at a departmental level, but just a note to remember that these consent forms and this process must be reviewed and endorsed by the REB before they're undertaken. So again, a little bit more about access to personal health information for research purposes without consent. So we already talked about the TCPS2 section, which is actually 5.5 in Chapter 5. So the REB request for waiver, excuse me, will guide you through this, and that's actually in the application form itself. So under Section 8 in the application form in the Romeo system, it actually asks you to walk through TCPS2 5.5 A through F. And I wanted to mention a little bit more about impracticability. So this is actually a legal term, and it discusses or talks about or encompasses the degree of difficulty that's related to the difficulty is higher than inconvenience or impossible. So it's impractical but lower than impossibility. So it means, anyway, it's a legal term. I always kind of struggle with this, but essentially what you want to say is it's impractical because if we have to go back and get informed consent from everybody, it's going to be impossible for us to do this research study. That's essentially what it means in a nutshell. So what are some of the justifications for saying it's impracticable? Well, so for secondary use of data, it's the size of the population you want to include in your study. And then perhaps there's a proportion of them that are likely to have relocated or passed away since the data was collected. There's a lack of an existing relationship such that if you contacted them, you could introduce bias, which could affect validity or defeating the purpose of the study because they may not agree to have their information included. And also the additional financial, material, human, organizational, and other resources needed to obtain consent could impose that hardship or burden on the researchers or organization, so much so that the research could not be done. So what about safeguarding personal health information and research? So as I mentioned, there is a section in the privacy legislation that states that researchers will take appropriate measures to protect the privacy of individuals and to safeguard the identifiable information. So how do we do this? We talk about this all the time, the rule of minimums, and that means only collect the information that is required to answer the research question. Sometimes we'll want to include other information as a just in case, and that's not best practice. You only need to collect the amount of the information that you need in order to answer the research question. And what about de-identification? So de-identification is another great way to protect personal health information, but it's only considered to be fully de-identified when you remove these 18 specific identifiers. Names is an obvious one, but geographic locators, all elements of dates except for the year. So if you think about if you're collecting, doing a secondary review on certain outcomes, maybe related to a surgical outcome, well, date of surgery is going to be a variable of interest to you. So that specific date is considered a quasi-identifier. Telephone, cell phone, fax numbers, those are all identifiers. Email addresses, IP addresses, social security numbers, Medicare numbers, medical record numbers, even device identifiers and serial numbers, because medical devices are assigned unique serial numbers. Driver's license count, vehicle numbers, full face photos, biometric identifiers, and any unique characteristics or codes. So this is actually the safe harbor principle for de-identification, which states that if all of these specific identifiers have been removed, then you can consider your data set to be fully de-identifiable. So now I just want to give you some specific examples of privacy incidences that can happen in research. So this isn't actually a research project, but there are it has some similarities to what can happen within a research project. So this just happened recently. So there was over 4,000 patients and 1,200 PEI employees were notified of a breach after an employee's laptop was stolen in April. So if you think about it, if you're doing a research project, if you're a student and you're located at a facility for the summer, but then you're not finished your data review, so you have to. Then your data becomes mobile. How do you port your data around? Well, you could store it on a laptop. A lot of people do. So you can see how this reasonably could happen. And the information that was on this specific laptop was directly related to patients. So it's emergency department. This even looks like a research study, right? So it's related to emergency department visits through a specific time frame, the reason for the visit, the diagnosis, the name of the treating physician. So name, dates, and healthcare numbers, gender, and postal codes were all included on this laptop. So if we relate this to research, it does really look like a secondary use of data research project, a retrospective review. And what this speaks to is what we ask you to address in your research study application is think about what your reasonable safeguards are to protect the privacy. So in this particular case, the laptop should have been encrypted. It really should be a Horizon issued laptop. There shouldn't be any identifiable information on it because identifiable information isn't necessary to your research project. Names can be replaced by study codes. So Joe Smith could be, participant number 001. Those types of things, and procedures to destroy the information or to de-identify it at the earliest opportunity, consistent with the purposes of the project. So this is how things, their intentions are good when you set out because you need your data, you need to analyze your data. How do you do it when you're mobile? There are ways that you need to consider to protect that information when you have it collected for a research project. Another example, a research questionnaire was completed by a research participant and sent to the study sponsor without redacting the name of the participant. So why is this an issue? Study sponsors are listed under the confidentiality section of the consent form as having access to personal health information. Well, the issue here is study sponsors do not get participant names. So this actually ended up in a privacy incident, and it had to be filed as a privacy incident, and we had to implement mitigating factors, which is that when a questionnaire is completed by a participant, that the study coordinator will ensure that the name of the participant is redacted before it's sent off to the study sponsor. It's a minor issue, but it's still a privacy breach, and actually this one did not require notification of the participant. But sometimes it does require that the participant be made aware that their personal health information or identifying information about them was released outside of their parameters of the consent. Another one, full name of a research participant was sent to a courier via email instead of the research pharmacist. So again, these are all very innocent human errors. We can see how they happen. but it was just the first name of the pharmacist must have been similar to the courier, so it's clicked. And so all the information about the participant, who they were, what treatment they were coming in for, so that the pharmacist could prepare. But when actually it went out, the courier came back and said, I don't think this was meant for me. So it's just, those double check systems, just to ensure that you have the right recipient in your email, and those types of things. And again, this was a privacy breach that needed to be filed. So what are some final thoughts? Consent is key. The default position is always to get informed consent. But as I mentioned earlier, there are exceptions. They can be permitted. Waiver of consent for secondary use of information can be approved by the REB. You need to understand your access rights. So if you're going to look at personal health information, consider, would you normally have access to this information within your current role? Determine your data collection approach and your variables of interest, and do that early. And remember the rule of minimums. So only collect the information that you need in order to answer your research question. Ensure that you have good data management practices and develop a management plan and map it out. So what I mean by mapping it out is map out the life cycle of your research data, from even before you're collecting it, right through the life cycle to the end to destruction, where it's going to be collected, where it's going to be stored, who's going to have access to it, and then subsequently what your data destruction plan is. And always you can connect with us in research services if you have any questions. I do get questions about, screening participants. Can we have access to, clinic lists to look for potential research participants? Well, that's outside of your scope. And it's not, that information isn't collected for that purpose. So those lists are generated to provide care, not for research. So that would be outside of the scope of that information. So those types of things are always available to answer your questions and to do consultations and to even look at your consent forms in advance of submitting them, because sometimes there are things in there that sponsors put in there that that wouldn't be permitted by either RAB or by the legislation. So we're always happy to do consultations with that respect as well.